All right. So
And I apologize. I had 6 hours of oral surgery yesterday.
Oh my gosh.
And it makes everything. You wouldn't think an 80-year-old would get teeth that are going to last for another century, but that's what they did.
Well, and you know what my doctor told my family members and told me? They said everything on your body is supposed to be able to last. So they're supposed to last.
Mine didn't.
A 2019 case finally hits center stage, State versus Tamar McIntyre. The judge weighs a continuance while funds dry up, and a new ballistics twist emerges. Stay close. One decision today quietly reshapes the entire trial.
We go off the record.
We're not on the record.
We're going to go to R.C. Buford's house for dinner, and I looked at my wife, vein is on, and I said, does my hair look all right? She said, shit, you forgot your teeth. All right. You've got to be 80 years old to understand that's something that...
Well, you know what? They did an excellent job because you can't tell.
Well, it hurts to smile, and there's still this lisp that is caused by there's a bridge that'll be there until December or something.
It adds to your charm, Jerry.
Yeah, right.
Thank you.
Thank you.
All right.
We're ready.
On this case, we had a discussion, and it wasn't ex parte. It was by phone.
Yes, sir.
So normally in this case, I wouldn't be giving you all a reset, not for vacations or for the state not having a witness. However, the state subpoenaed a witness, had them bench warranted, and they did it in a timely fashion. They didn't do it last minute. Bear County has no money to bring that person here until the 31st. And I spoke to y'all by phone, and my understanding, neither party had an objection to continuance. You have your trip you have to go on.
Yes, sir.
So I don't think it would be fair to place this continuance on either the state or the defense.
I don't mind begging for it if it has to be on me. The state, and I think all of us appreciate it. We are going to probably have to try this case, and I think all of us would like some time. This expert witness that we've got, we are going to need an order from the court to allow him to review and conduct testing on the ballistic testing on the weapon that the state located, I believe, on August 20th.
Yes,
16th or 20th.
I don't know if you received that motion.
No, let me see if they put it in the file for me.
The defense did file a motion for continuance, but I do appreciate, Judge, neither side is really at fault for this. But I think that what's contained in there probably needs to be addressed.
I'm highlighted.
Thank you.
Copy yours.
I will tell you, Odyssey and e-filing. All right, so I see what your issue is in your motion for continuance. But again, as I said, I'm not going to put the motion for continuance on either party. We're just going to do a different date. But I will tell you both, this case is going to be tried before the new year. All right. So then the issue with regards to anything that I need to sign as it relates for testing, do y'all have a motion for that or no?
We will have it here within a matter of hours. I dictated it this morning. Our expert, as the motion provides, says that it's going to take him 40 to 60 days to conduct the examination, be able to testify.
The issue.
Key ruling. The judge grants a continuance on her own docket, not blaming either side. The state can't fund a witness until October 31st, while defense needs testing time. Fair call or frustrating delay for justice?
I believe is
Ed Huskey.
Huskey, Huest.
Well, is there any way that he can do it at the state lab? And
I don't know if they would allow that, Judge.
Yeah.
That's something I could ask.
yeah,
of
so
course,
I mean, let's pick up the phone and ask. Maybe that will be quicker.
I'll be happy to ask.
For the courts, science is science, right?
Right.
If people are allowed to do their testing, and of course, if you do it through the state's experts office, or lab. I don't think your expert has to say anything to them. More likely than not, they may not allow that, but at least that's an option to consider.
And we ought to consider giving him that opportunity if we're going to pick a date certain. That way we don't have any issues.
Oh, we're going to pick a date certain.
All right. If we could put it off until mid-December, at least that way we're going to do it before the first of the year. I believe I have a speech to the Florida Bar on the 14th and 15th of December, but other than that, I'm clear in December.
And Judge, just,
Like, how long are you all expecting this trial to last?
I expect, 2 weeks.
I think
And Judge.
2 weeks will be ample.
I'm assuming you're looking for, like December 9th or 10th, somewhere in there, because that's the dates.
I'm looking at December. Well, we can't do it December 2nd because that's R.C. Curtis.
The following week, Judge, we do have, I think, 1 murder, 2 intox manslaughters, and then some other higher profile cases. But of course, those would have to be pushed. I just want to make sure you're aware of that.
All right, this is what we're going to do. We're going to set this for December 2nd, and I'm going to see where everybody is with their expert. So you all need to get on the ball. I know it's late as far as you're knowing that you need an expert for this specific issue, but I'm going to set you all for December 2nd. We're going to come back here and see where we are.
That's fine. And I will get you the motion so that we can get that rolling today.
And
Where's
just-
Quincy, MD, when you need him? Quincy would have already done this.
That was great. One thing else is that I just.
We got Husky. That's close.
I
So
just want to make sure that I'm assuming that y'all obviously want the weapon that was gained as evidence up in Dallas. We should have that here still.
That's
But
correct.
we will also like the shell casing that was brought in.
absolutely. He needs to do
So
the
we just gotta
comparison.
make sure that that's in the motion with the item number.
We will put both of those in the motion.
Good.
All right, so
Thank
the
you.
case that's being tried is the 2019 case, correct?
And Judge, if that's the capital murder,
Yes.
that
Yes.
would be correct.
All right, so we're going to go on the record with this. Court is calling 2019 CR 12495 State versus Tamar McIntyre. If I can have all parties announced for the record, State,
Jason Garahan for the state, Your Honor.
defense.
Jerry Goldstein and John Hunter for the defense, Your Honor. We're ready to proceed.
All right,
On
and
the
are you,
motion for continuance.
all right, and are you Mr. McIntyre?
Yes, ma'am. Yes, ma'am.
All right, so off the record, both parties agreed that neither party should be charged with the motion for continuance. The issues are the state timely requested that a witness be present. However, due to county funding, they're not going to be able to pay for transportation until October 31st, correct, State?
That's correct.
And then the defense, there was a weapon that you wanted tested.
That's correct, Your Honor. It appears that it belonged to a co-defendant that was at the scene.
All right. And it's the court's understanding that this wasn't something that y'all learned about months ago and you're just now bringing it up. Am I
No.
correct?
That's correct, Your
We
Honor.
discovered it in August and made the parties in the court aware of the issue and
And the state
family to try and get it
the
tested.
state diligently exercised diligence in looking for the weapon. They did discover it. They did have it ballistically tested, and they have advised us, I believe it was 2 weeks ago, of their results, and we have asked that we be permitted to have an opportunity to have an independent examination by the defense expert.
All right. And your expert can't test it right away because he has no laboratory currently.
Correct. We have to get the gun from the police. We have to get it to a laboratory. And
Legal note: defense's expert lacks a lab, so the court floats using the state lab to speed ballistics. If permitted, it preserves chain of custody and neutrality, minimizing later appeals over testing access and timing.
And then that may not happen, but that may speed things along.
We appreciate that, Your Honor, and we
I'll
appreciate
check with
counsel.
Mr. Husky to make sure that that's, satisfactory to his method. But I mean, I don't see why it wouldn't be based on what we know now.
All right. Anything else?
Nothing from the state, no?
Nothing on behalf of the defense.
Any other discovery?
No, Your Honor, we have had an e-discovery problem now for several months, which Jason and I have talked about over and over and over again, and they've given me another terabyte hard drive full of all the materials that I think were produced since our discovery compliance hearing, which namely pertain to written correspondence of the defendant's jail correspondence. And we're still going through all of that. There's a lot of it, but I don't think most of it is relevant to the case. And Jason, correct me if I'm wrong. I don't think that there's a plan to be introducing much of it, if any.
That's correct. I mean, its volume is jail mail, Judge. And then also, there is additional stuff that may be filed. And so I don't know if y'all still have access or not, because I've talked to the paralegals on it. I think we have it hashed out. I think we have it put away, Judge. But, I think that everything's been sent over. No, I don't think. I know everything's been sent over now with a terabyte drive. But then I will also contact defense counsel if any additional evidence or anything else is uploaded.
If they do, we may be addressing it with the court, but I presume we were just talking about mail.
Correct.
Okay.
That's correct.
And I'm also sympathetic. I know that the way y'all's office runs things, sometimes when there's a disclosure of a new piece of evidence, even if it's a scrap of paper, we sometimes get notification about a ton of stuff, most of which we already have, that creates this. That's no one's fault. And I think.
Quick reset. Discovery just ballooned. A terabyte of jail correspondence and filings, yet most may be irrelevant at trial. The real pivot is the newly found pistol and shell. Next, scheduling locks deadlines that force progress.
In this court years ago, we
It
moved.
got transferred last year.
Yeah, it got transferred.
It was over in juvenile, it was over in juvenile for years. And then, of course, this case, because of the legal issues this individual has had in other counties, finished up there, and that's why it was brought down here and then transferred to the court for his adult status.
And we came with it.
Okay. All right. So then instead of the December 2nd date, what I'm going to do is I'm going to set you all for November 21st. And on that day, I'm going to expect everybody to be prepared to sign an acknowledgement for discovery.
Yes, sir.
And if there is an issue with some discovery, that needs to be addressed at that point.
Yes, sir.
And that's November 21st, Young?
Yes. All right. And do you want Mr. McIntyre present, or Mr. McIntyre, do you want to be present? Because that's on that day, it's going to be whether or not your attorneys have all of this discovery. I will tell you, Thursdays are usually heavy dockets for us. If there's an issue where they don't have something and they think they should have, then that will be addressed on December 2nd, and you can be here for that. So it's completely up to defense and you. If you want to be here on November 21st, we'll have you brought over.
No, ma'am. No, thank you, Your Honor.
All right. So November 21st, just so we're clear, that's for state and defense to make a determination if you have all of the discovery. If you do, you'll sign the discovery of acknowledgement.
Yes.
And then Mr. McIntyre, we will bring you back on December 2nd. So the only thing that will be happening is really in your attorney's purview. Do they have all the discovery or not? If they say they don't, then we'll address it on December 2nd. But most definitely, you will be here on December 2nd, because that's the day we'll see where we are with trial.
We will have a motion to Your Honor today on the production of the weapon and casing.
All right. And then, Mr. McIntyre, we can go off the record for trial, and I know your attorneys know this. You will be brought over dressed in whatever civilian clothing you have at the jail. If you wish to be attired in something different, you'll have to do a clothing exchange. And sometimes attorneys will tell me there's an issue with the clothing exchange. If there is, let the court know, and we'll see if we can help expedite that.
Definitely. Your Honor.
To that point, Your Honor, I was going to ask, this offense happened some time ago, and McIntyre has been measured for nice clothing in a long time. We wanted to go about getting him measured so that we can get him clothing that fits for the
Who
trial.
will be measuring him?
I wanted to just ask Your Honor how you wanted us to address that.
No, I mean, it depends on who's measuring him.
I assume it will be a tailor from some retail shop that is gonna
Deputy,
size him.
let me ask you this. They don't know what size he wears. So if possible, I'm assuming a tailor, all they need is a measuring tape.
That's correct.
Will we be able to
And a
have,
pad to write it down.
and a pad to write it down? Will we be able to bring him over and they can measure him? So, coordinate with the deputies. They'll have him brought over and make sure the tailor person is here and they'll be allowed to measure him.
We appreciate that. Thank you for the cooperation.
Thank you, Judge.
Is there anything else?
No,
All right, and just coordinate with a day with Deputy Laura, maybe where we don't have a big docket or don't have a docket, and she'll work with you on that.
Be happy to do that.
All right, thank you. Is there anything else?
Nothing on behalf of the defense. May we be excused?
All right, well, any questions, Mr. McIntyre?
No, ma'am.
All right, thank you.
Thank you.
Thank you, Judge.
Oh,
You do have a
I
question?
did have a question. I'm sorry.
Yes.
Can I talk? Is there anywhere I can like stand?
Oh, sure.
Yeah.
They need to speak to him some more.
Bottom line, continuance granted, independent testing pursued, and firm dates set before year's end. Justice moves cautiously. What's your take on this balance? Drop a comment, hit like, and subscribe for more dramatic courtroom moments.